including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material from this program should not be viewed as a substitute for personal consultation with an attorney. Welcome to Talk Legal with Jeff Van Treese, who brings you all the latest news in the legal world. Jeff will be discussing a variety of legal topics with experts in the field. If you would like to ask a question or share a story on the air, please call toll-free 888-565-1470. Once again, that's 888-565-1470. Now, let's talk legal with Jeff Van Treese.
Good evening and welcome to another edition of Talk Legal. I'm your host, Jeff Van Treese. I'm an attorney with the law firm Oltman, Flynn & Kubler, where we specialize in intellectual property law, including patents, trademarks, and copyrights, as well as elder law. You can check us out online and view all episodes of this show on our website at oltmanpatent.com. That's oltmanpatent.com. I would also like to acknowledge our other sponsor, Fresh Start Tax. Fresh Start Tax offers a full range of accounting services, including basic tax returns, as well as assistance with tax levies, wage garnishments, and any other tax-related concern. You can find out more by visiting their website, freshstarttax.com. I'd also like to thank all of our listeners, including those of you tuning in on the AM dial, as well as those watching online. If you have a question, comment, or story that you would like to share on the air, please feel free to call us toll-free at 888-565-1470. Once again, that toll-free number is 888-565-1470. We welcome your calls. This evening, my guest is going to be Ed Ricci from the law firm Searcy, Denny, Scarola, Barnhart, and Shipley up in West Palm Beach. Ed should be here any minute now. He's actually running late in traffic, and I'm expecting him to walk in hopefully very soon. Ed specializes in personal injury law as well as products liability and a number of other areas. What we're going to be discussing this evening is insurance and issues that can come up with auto accidents. Specifically, we're going to be focusing on uninsured motorist coverage, that is uninsured and underinsured motorist coverage, which is a form of insurance that you can purchase that insures you against loss in the event that the other driver, if you're in an accident, either doesn't have insurance or they don't have enough insurance to cover you for all of your injuries. So that's going to be what we focus on when Ed arrives here, hopefully in the very near future. Before he gets here, I'll just talk about some of the topics that we're planning on discussing. Florida is a comparative fault state. What that essentially means is that the damages, if you are in an auto accident, are apportioned based upon how much fault each party has. So this is something that is left to juries to decide, in terms of if one party might be 50% at fault, another party might be 50%, or one party might be 100% at fault, and so forth. And here's my guest right here. This is Ed Ricci. I introduced you right before you got here. You got your microphone? There you go.
Thank you.
Ed was stuck in traffic. That happens here in South Florida, but so glad to have you. Thanks so much for joining us.
My pleasure. Thanks for having me.
So as you were running in here, I was just telling our listeners about what uninsured motorist coverage is, being a form of insurance that insures against the other driver if you're in an accident not having enough insurance to cover your injuries. If you could just tell us a little bit about it and when somebody might come to see you in the event that they're in an accident.
Sure. Well, uninsured motorist coverage, it's really uninsured / underinsured motorist coverage. And what it does is it insures you against the risk that you're going to be injured by somebody who either has no coverage or very little coverage. And it's common in my practice that people come in and they say, hey, I have full coverage, I've got insurance, and I'm hurt, I was involved in a crash, and then we look into it and we come to find out that the at-fault driver has no coverage. And then if the injured party hasn't purchased uninsured motorist coverage, they find themselves in a position where they're hurt, they've got significant medical bills, and there's no insurance to pay for those losses. And frequently people are very upset when they learn that.
Now, in Florida, you're only required to have PIP, or personal injury protection insurance, PIP coverage. That's just something very different from uninsured motorist coverage, isn't it?
Yeah, that's correct. Florida, I've done some research, and there's a group that's called the Insurance Information Institute. Florida has is ranked number 2, at least according to a study from 2012, that we have right behind Oklahoma. According to this, we've got 23.8% of drivers on the road have no coverage. And in Florida, what you're required to purchase is, like you said, personal injury protection. That is just, that's a no-fault type of coverage, meaning it doesn't matter who causes the crash. It's for the people in the car, and it covers medical bills up to $10,000. And recently in our state, they've enacted some changes to that statute that requires that coverage. But what many people are surprised to find out is that Florida does not require that people carry coverage in the event that they hurt someone else. And so there are many drivers who say, hey, I have full coverage, and they have $10,000 in the personal injury protection, but in fact they have no coverage in the event that they injure someone else.
And it's possible that somebody might hit you, and they may have coverage, but it's only for damage to the vehicle, not for bodily injury.
Well, they would be required to have property damage coverage and personal injury protection, but no, they're not. No one is required to buy bodily injury coverage in the event that they hurt someone else.
Now, how about the role of policy limits? Because these policies have limits on what you can collect. So if you are in an accident, and let's say there's a policy limit of $100,000, but let's say you're grievously injured, and you may have injuries and medical bills and lost wages that are even greater than that. Are you capped at that $100,000?
Well, there's a practical answer, and the practical answer would be, in all likelihood, you would be if the person who had the $100,000 policy limit had assets beyond that, then you could attempt to collect against those if you went ahead and got a judgment against them.
Now, if the insurance company decides to fight and you end up going to court, then under some circumstances those limits might disappear, and you might actually be able to collect more than the policy limits and under some circumstances.
Yeah, you're getting into an area that's called insurance bad faith, and there are certain circumstances where if the insurer does not act with due regard for the interests of its insured, and they act in bad faith, that there is a potential that a recovery greater than the policy limits could be obtained from the insurance company.
So one of the major differences between going after another driver and their insurance company versus having uninsured motorist coverage in the event that you do have to file a lawsuit and go to court is that the jury gets to hear about the uninsured motorist coverage being a party, and that's not the case otherwise. If you could explain that.
Sure. In an uninsured motorist case, if you take the case to trial, I tried one last year. The case is brought against a named insurance company, so the jury is going to know that insurance is involved. In the event that a claim or a case is being brought against just an individual, whether or not that individual has insurance is not something that a jury is allowed to hear or consider.
So if you're have a situation where the uninsured motorist coverage and the other driver's insurance is the same company, is that you're dealing with one defendant, or are you dealing with multiple defendants?
Well, it would depend, but you could conceivably have a scenario where there's a claim against an individual driver as well as an uninsured motorist carrier. In that event, whether or not the individual driver who's a defendant in the case has insurance is not something the jury would not be allowed to find out, oh, well, hey, it's State Farm for the uninsured motorist claim and also State Farm for the bodily injury. They wouldn't know whether that person had insurance, whether they were underinsured or uninsured.
So you are in an accident and you get hit by John Doe. It's just the only thing the jury hears is that you're suing poor John Doe. That's it.
Correct. If there's no UM claim, then all the jury would know is that John Doe is a defendant, and the jury might believe that John Doe is personally liable, which he would be, but he in all likelihood would have some insurance coverage to protect him in the event that happens, but the jury would not be told that.
They wouldn't be told that, but it seems as though this is something that I'm curious. Wouldn't they sort of figure it out? And because if John Doe's being represented by an insurance company, he's going to have experts that the insurance company is hiring and so forth. It's clearly going to be a big production that's clearly costing a lot of money. If I'm sitting on a jury, I can't imagine that this person that's an individual is paying for all of this stuff. I have to assume that the insurance company is probably playing a role here.
Jurors are smart. I would not be surprised if they could see through that and figure it out. But it's just not something that would be openly disclosed in the trial. The liability insurance would not be permitted to be discussed at all, although I think most people probably do figure it out.
So when you're dealing in a case like this and you're doing jury selection, what are some of the most important considerations for a personal injury claim?
Well, when it comes to jury selection, I mean, really what you're looking for is for people who do not come into the courtroom with any preconceived notions. You're looking for people who can be fair and impartial. So it's really, jury selection is sort of a misnomer. Most people would refer to it almost as jury deselection, where what you're trying to do is you're trying to get people off the jury who have really, really strong feelings against your client for any number of reasons, or against personal injury lawsuits in general. You're trying to get essentially someone who's got a clean slate, who hasn't prejudged the case and is not bringing anything into that courtroom that's going to negatively influence their view of the case. That's what you're looking for.
We're going to take a short break, and we'll be back with Ed Ricci. Stay tuned.
This program is brought to you by Fresh Start Tax. Fresh Start Tax offers a full range of tax and accounting services, including tax return preparation and bookkeeping, as well as back taxes, wage garnishments, unfiled returns, or any other tax-related concern. Our dedicated team of tax attorneys, CPAs, and former IRS agents offer over 60 years of professional tax experience. For a free consultation, call 866-700-1040. That's 866-700-1040. You can also visit us on the web at freshstarttax.com. This program is brought to you by the law firm of Altman, Flynn, and Kubler. Our law firm specializes in elder law and intellectual property, including patents, trademarks, and copyrights. If you would like to patent your idea, please contact our Fort Lauderdale office for a free consultation. We offer elder law services, including estate planning, long-term care planning, and preparation of healthcare documents. We strive to plan for your future needs while allowing you to retain as much dignity and independence as possible. To find out more or to make an appointment, call 954-563-4814. That's 954-563-4814. Or visit us online at altmanpatent.com. That's OLTMANPATENT.com. Spokesperson, not an attorney. You're listening to Talk Legal with Jeff Van Treese, who brings you all the latest news in the legal world. If you would like to ask a question or share a story on the air, please call toll-free 888-565-1470. Once again, that's 888-565-1470. Now, back to Talk Legal with Jeff Van Treese.
And we're back. My guest this evening is personal injury attorney Ed Ricci. He's with the law firm Searcy Denny, Scrolla, Barnhart, and Shipley, in West Palm. We've been talking about uninsured motorist coverage and about car accident litigation. I'd like to turn our attention now to some practices from the insurance industry that I know you're all too familiar with. From recent reports that have come out, it appears that insurance companies have been fighting auto claims just vigorously in recent years, and they seem to have some reasons for doing this that are sort of a little bit less than above board. That is, that they either deny claims entirely or they offer very little, much less than should be a reasonable settlement offer. So if you might tell our listeners about some of these practices and what you've had to deal with.
Well, in Florida, a lot of people don't realize that before you can recover for pain, suffering, mental anguish, loss of enjoyment of life, you have to prove that you have sustained what's called a permanent injury. And a permanent injury essentially could be a loss of important bodily function or an injury that is permanent within a reasonable degree of medical probability. And before you can make a recovery for any sort of pain and suffering damages, you have to make that showing. So insurance companies defend claims. They have every right to defend claims. However, there are a certain group of doctors that are go-to doctors that they might send an injured party to have a medical evaluation done. And very frequently what you'll find is that these doctors, they use boilerplate type reports, and time again, they come up with the opinion that the injured party has not sustained a permanent injury within a reasonable degree of medical probability. So if you've got someone, for example, who is over the age of 50, I mean, there's a good chance that they're going to have some degenerative changes in their neck or in their spine, right? Because as we age, our bodies break down. And so that tends to be, in South Florida, we've got an aging population here. It's a big retirement community. And so if you've got an older person and they're involved in a crash, I can almost guess what's going to be in these reports, before I get them. And most oftentimes I'm right about what's going to be in them. So fortunately, we are able to cross-examine these witnesses and try to expose their potential bias by showing how much money they make through doing defense work, if it's a claim against an individual who's being represented by an insurance company, or if it's against an insurance company, the jury's allowed to hear how much money the doctors are making doing these medical examinations. So that gives you some flavor for what's going on. I think insurance, they go through cycles. It's been our experience in recent years that it seems like right now the insurance companies are in a posture where they are fighting claims. And I think that what they're finding is that if they say no frequently enough or make unreasonable offers, that a lot of people don't want to go through all of the trials and tribulations associated with litigation and see it through to its conclusion. So people are getting beaten down and are settling cases perhaps for less than they're worth.
So, and of course, a lot of it is to send a message to plaintiffs' attorneys that they want to make it as hard for you as possible to settle a case or to achieve a verdict for your client. If something is dragging on for years and years, that's going to be a lot less desirable. And if it's something that's going to cost money, because for the plaintiff's attorney, they usually have to front all of the costs, including the costs of bringing the doctors in to testify. And so if you either lose the case or if the case goes to trial and it becomes expensive, then it's something that might be less desirable to fight. And that might be really what they're going for. They might lose money on one case, but they think that by doing that, they might prevent other plaintiffs from suing them.
I think that that's accurate.
So, from my understanding is that it's a posture from insurance companies to deny the claim and then to delay, because when they delay, you might be injured after the accident, but if your trial is 5 years later, you might not have any noticeable injuries when you walk into court. And then the jury might think, well, there's nothing wrong with this person. But they may have been in very serious pain for 1 or 2 or 3 years after that injury. I mean, I'm sure you've seen that.
Absolutely.
So, one of the things that often comes up in these contested auto accident cases is where you have a situation where there's a low impact crash, or where you have something that's at 5 miles an hour or something like that, or you have a rear end collision, in which case there might be minimal damage to the vehicle. And then the argument that the insurance companies make, or their attorneys make for them, is that the low impact of the accident means that the injury to the person can't be that great. And of course, medically, this appears to be nonsensical for obvious reasons. Our bodies are not made out of steel like cars are, and can't withstand injury the same way that a car can not be damaged if it's hit. So how do you combat this? How do you combat these arguments that they make?
Well, injury causation is something that in certain cases we would have to bring in a biomechanical engineer. The person's body mechanics. If somebody's, for example, looking to the left for oncoming traffic, when they get hit, well, guess what? Their spine is torqued. The vertebrae are out of alignment. So they may only get hit at 5 miles per hour, but the effect on the spine is going to be exaggerated by the fact that the neck is in a torqued position. So it's important to look at what was the body position of the occupant at the time. It's important to, although there may not be a lot of visible damage, oftentimes we will put the car on a lift, remove the bumper, and look underneath the bumper, and you'll see that there's usually plastic with styrofoam, and then underneath there will be the actual metal that shows where the bumper is. And sometimes what you'll find is that there was damage to the metal inside the bumper, behind the styrofoam, that you can visibly show and demonstrate as showing severity of impact, even though there's not the plastic on the outside doesn't look too bad. The other thing that you're going to be looking at is momentum. If the body gets subjected to momentum over a short period of time, then that's going to be more likely to cause injury. So that's the reason why you've got styrofoam in the bumpers, is to dissipate the momentum, so that the momentum, as the force is transmitted to the occupants inside the vehicle, if it happens over a longer period of time, the likelihood of injury is going to be less. But if you can show that it happened over a relatively short period of time, then it's going to jostle the person inside the vehicle more, throw them back into their seat. You might see a whiplash type of injury, yet the car looks fine.
And of course, there's something that's called the eggshell plaintiff rule, which means that the defendant takes the plaintiff how he finds him. So if you are someone that is highly vulnerable to injury, let's say that you've had back surgery last week, you just had back surgery, and then this week you're in a car accident, you might be your injuries might be much more severe than somebody that has a healthy back or healthy spine. But that's something that the defendant still is going to be responsible for. Your medical bills, your medical costs, your pain and suffering might be much greater, but that doesn't matter. The defendant, in this case the insurance company, is still going to be liable.
Yeah, in Florida, if someone has an aggravation of a pre-existing condition, they can make a recovery for that. And I'll just give you an example. My father's spine is fused, I think, at 3 different levels. And so if he were in a position where he gets rear-ended in a relatively low-speed impact, he's in all likelihood going to suffer injury more so than if you had an 18-year-old who's a football player and has got a healthy back. I mean, the chances of a young person sustaining injury in a low-impact type crash is going to be much less than if you've got an older person who's got an aging spine.
Well, We are running out of time. I'd like to give a very special thanks to my guest, Ed Ricci. Ed, if you could tell our listeners how you can be reached in the event that they are in need of your services.
Sure. We've got a website, cerseilaw.com. That's probably the easiest place to get information about our office and about what we do. Also, we've got a phone number as well, which you can find on there. But probably the website would be the most. It would be the easiest way to reach us, www.cerseilaw.com.
And of course, you don't just do auto accident cases, you do some other areas of law as well.
Yeah, I mean, we do all types of personal injury, whether it's medical malpractice, products liability, automobile accidents, premises liability. We pretty much run the gambit as far as that's concerned.
Well, thanks again, Ed, for joining us. You've been listening to Talk Legal. I'm your host, Jeff Van Trees. Please tune in next week, Tuesday night at 6 o'clock, where my guest will be attorney George Frank, and we'll be discussing homestead law in Florida. I'd like to thank all of our listeners, and have a great evening.
Thank you for listening to Talk Legal with Jeff Van Trees. Tune in next week for more insightful and exciting information about the law. You can contact Jeff by email at jvt2law@gmail.com or give him a call at 561-789-6866. That's 561-789-6866. The content of the preceding program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material of this program should not be viewed as a substitute for personal consultation with an attorney. The opinions expressed